Hey guys, welcome to this video. My name is John Watts. We're going to talk about a very, very important case from the 11th Circuit Court of Appeals from about 3.5 years ago, but it's still very valid today. This is called Hinkle versus Midland Credit Mgmt. And Hinkle is a consumer, and she sued Midland Funding, Midland Credit Mgmt, Encore, we'll just call all those Midland. She sued them for a variety of things, but this court focuses on the Fair Credit Reporting Act, the FCRA, part of her claim. And basically the issue is you go to the credit bureaus, so Equifax, Experian, TransUnion, you make a dispute with them and say, I dispute these Midland accounts. Then the credit bureaus reach out to Midland and say, hey, this lady is disputing these accounts. And Midland then has an obligation under the Fair Credit Reporting Act to investigate. Now, the credit bureaus do as well under the FCRA, but so does the furnisher. And Midland is a furnisher because it has furnished or provided information to the credit bureaus. So the question that the 11th Circuit Court of Appeals faced is, what's the standard? We know they have to do an investigation, but how do we judge whether or not that investigation was proper? And so this was the first time the 11th Circuit had considered this, and the 11th Circuit is in charge of the federal courts in Alabama, Georgia, and Florida. And the court goes, well, look, we've got to decide, is this an original creditor? Is this a debt buyer? Is this the sort of the first debt buyer, or a debt buyer who bought it from another debt buyer who bought it from the original creditor? And how does this Fair Credit Reporting Act law fit together with what the credit bureau must do and what the furnisher or Midland must do? And the immediate context of this case is these accounts were not her accounts. I mean, she did not owe these debts. And she told Midland that. She told the credit bureaus that. And we'll see ultimately the trial judge, the district court judge, threw out all of her claims. And then she appealed it to the 11th Circuit. So it's a somewhat lengthy opinion, and I've highlighted a lot of it to hopefully make it kind of stand out as we go through it. So if you say, I'm not interested in reading an opinion or watching a video about this, then this would be a great time to stop watching. If you say, well, I only want to watch a 5-minute video, this is not going to be a 5-minute video. I don't know how long it'll be as long as it takes to get through it. But if you're interested in how the Fair Credit Reporting Act works and exactly what is the obligation on the furnisher, particularly when they're a debt buyer, I think you'll find this case very interesting. So let's go down here. So this part I've already talked about. The trial judge, district court judge threw out everything, and the 11th Circuit affirmed or agreed with that decision except on the Fair Credit Reporting Act and one specific part of it which applies to furnishers, and that is section 1681 S2B. So what we have down here in red, that's the section that applies to the furnisher when you've disputed through the credit bureau. Now there's another section called 1681 S2A that it sounds great, but you can't sue on that. Okay, so when you're looking at the Fair Credit Reporting Act, you have to make sure, okay, this provision sounds wonderful. Do I have the ability to sue on it? In 1681 S2B, you definitely have the ability to sue. So here's some background. I think this is important because there's a lot of misunderstanding about debt buyers. Can they really buy debt? What happens when a debt is considered charged off? Does that mean it's not owed? And the 11th Circuit lays it out very, very clearly here. So we have a consumer debt is when you have a bank, credit card company, cell phone provider, whoever it might be, an original creditor extends credit, and then the consumer falls behind. Then the creditor will eventually, and they say be entitled to, but it's actually a requirement, after a certain period of time, usually 6 months, to charge off the debt. And that's because of accounting principles, it's because of some tax concepts. But understand this, it has nothing to do with whether you still owe the debt. So charged off debt is deemed uncollectible, treated as a loss for accounting purposes. But look at what's here in green. But charging off a debt does not diminish the legal right. Let me say that again. Charging off a debt does not diminish the legal right of the original creditor to collect the full amount of the debt. Now, we may say, well, I wish it was something else, or somebody told me, or I saw a video one time, or somebody told me, when we went off the gold standard, charged off, none of that matters. I'm just telling you, the court is accurate here, and this is a very consumer-friendly court for the most part, and they're saying, look, charged off debt, you still owe it. So what happens when it's charged off? Well, there's two things a creditor can do. First, they can continue attempting to collect the debt itself, utilizing internal collection staff. So say I owe Capital One, I don't pay, they charge it off. Well, Capital One can continue to write me and call me. Once they charge off, they're not forbidden from doing that. They can certainly still do that. Or they can contract with a third-party agent, a collection agency. So not talking about selling the debt, just talking about saying to this collection agency, so imagine I'm Capital One. I say, look, I still own this debt, but I want you to go collect it for me and I'll give you a percentage. Now, here's the alternative. Original creditor may choose to sell the debt to a third-party purchaser, a debt buyer, at a discounted price. And that discount's going to depend on how likely it is the debt buyer thinks that they will be able to collect on this debt. When original creditor sells the debt, the original creditor relinquishes its right to collect the debt and transfers that right to the debt buyer. And so the original creditor washes its hands of the debt while still recouping a fraction of its losses. Now, let me say this, and I probably will just say this once or twice. We have lots of videos that talk about why these supposed debt buyers often cannot or will not prove they own the debt. But for purposes of this opinion, let's just assume Midland owns these debts, because there's two debts that they say, hey, we bought, and they say to this lady, you owe them, and she says, no, I don't. They weren't my debts, and she disputes them on the credit report. So let's keep going here. The buyer of a debt on secondary market enjoys essentially the same prerogatives. So as they try and collect it, they can, number one, collect it themselves or hire a collection agency, or they can sell it. Now, when they sell it to somebody, and the court describes that entity as a down-the-line buyer, an even deeper discount, then that down-the-line buyer can choose whether to engage in collection activities or sell the debt. And debt that's sold repeatedly is often called junk debt. So, Capital One says, hey, we charged it off, we can't collect it, let's sell it to Portfolio Recovery. Portfolio tries to collect it, they can't collect it. They then sell it to Unifund. Unifund can't collect it, so then they sell it to Midland. And then Midland says, okay, now we're collecting it. Now, if all those people truly owned it at the proper time, then Midland has the right to collect it. But of course, that's a big if they truly bought it. And so the court points out that particularly as you get down the line, but even sometimes the first debt buyer is sold as is. So you get electronic data, you get in essence a spreadsheet, but you're not getting account level documentation. Well, what is account level documentation? Well, that's going to be applications, agreements, billing statements, promissory notes, checks, payment histories, that type of thing. So this case involves two such junk debts. We got GE and T-Mobile. Midland purchased as is without that account level documentation, and they were not the first company in line. Okay. So let's focus now on this GE debt. They bought it from AIS. It was sold as is. AIS said, hey, it's accurate to the best of our knowledge. Of course, AIS didn't have anything to do with putting this information together, so they don't really know. Midland acknowledged in the purchase agreement account may be an unenforceable debt, may have little or no value. So probably last time I'll talk about these purchase agreements, because we talk about these in other videos. This gives you an example of why when they sue you, they do not want to bring these into the court, because they come in, they go, Judge, our documentation, it's the gospel truth. Why would you possibly question our documentation? We bought this. Well, if the purchase agreement says, oh, by the way, this may be unenforceable, it may have little or no value, it's sold as is, we have no idea if this is accurate, that kind of hurts the debt buyer. So that's why they don't want to let this stuff out. And the court points out this is done to lower transaction costs, facilitate the quick sell, and the lack of account level documentation can prevent debt buyers from litigating disputed debts on the merits. Now that's true in certain places, like the court points out North Carolina and maybe Nebraska say, you know, you've got to have this information to pursue things. But I'll just tell you, in Alabama, you don't have to have that to pursue, but you have to have it to prove your case, at least if the consumer lawyer, challenges that in court. But let's go back to this opinion here. So AIS, that's who Midland bought this first GE account from, said they'll assist Midland in getting the documentation from the original creditor. So that's important. So a week after they get the debt, Midland sends a collection letter, and then they get paid. But we don't know who made that payment. And then they report to the credit bureaus that it belongs to this client. And then they zeroed it out and says paid in full. And then they stopped reporting after March 2009. So that's what's happened. Hinkle says, hey, I didn't pay that debt. I didn't get any correspondence from you. I don't know anything about this. I just pulled my credit report in 2011. So look, they stopped reporting basically in 2009. So 2 years later, she gets her credit report and it's like, wait a minute, what's this Midland account doing on here? So she disputes with the CRAs, the credit reporting agencies, Equifax, Experian, TransUnion, and say, look, this debt did not belong to me. So the CRAs notified Midland saying consumer states inaccurate information, identity fraud, fraudulently open. So CRAs tell Midland verify name, address, social security, dates, and balances. Now, she also sent a direct letter to Midland saying, I never had this account. I want you to validate it. Midland did nothing. Why? Because it had already marked the account paid and ceased to report it to the CRAs. So we'll come back to that in a moment. So a little bit later, so remember this is all in September 2011, December 6, 2011, they get a T-Mobile, $300. And they purchased it from Debt Recovery Solutions, sold with limited warranties. And if we drop down, look here at the footnotes, DRS warranted to the best of its knowledge was true and accurate. But of course, they have no way of knowing it. Backing up to that AIS, that's that GE account, they said AIS will contact the original creditor and will get that for you, that account level documentation. So go back to the body here. So the only documentation they received was a data file, and Midland had to get the express written authorization from DRS before requesting account level documentation from the original creditor. In other words, when these original creditors sell things, they don't want somebody maybe 5 steps down the line to start issuing edicts to them like, hey, you must give us all this documentation. Like, hey, we sold it to, portfolio. We didn't sell it to you, Midland. So you don't make demands on us. That's typically how this works. And so DRS says, hey, we'll act as an intermediary. And there's a little bit of dispute about exactly how far Midland can push that. Okay, so December 21, Midland sends a collection to Hinkle, and they call her. She disputes it, says that account never belonged to me. So they record the dispute as fraud or identity theft. So now we remember that's December. February, they sent her a letter and they say, as part of our investigation, it would be helpful to have a copy of any documentation you have that supports your dispute. Well, just stop there for a moment. What in the world would she have that would support her dispute? If it wasn't her account, what can she say other than, it's not my account? She's not going to have a document that says, it's not my account. So it's kind of a stupid letter for Midland to send, but it's just a form letter. And you'll see in this case, what they're trying to do, both from kind of a practical standpoint, but also a legal standpoint, is shift the burden onto the consumer and say, well, until you get us more information, we have no obligation. Yeah, that doesn't go so well for them here. All right, let's go back to the opinion here. Internal records note that notwithstanding disputed status, it was okay to work because the dispute was outside the validation period. Consumer needs to send proof. So let's talk about that. The validation period is when Midland sends you a letter, and typically it's the first letter, but they can put it on other letters also. And they say, hey, you have 30 days to dispute this debt. Well, there's a lot of misunderstanding, and the debt collectors, they know what the truth is, but they pretend to not know the truth. The truth is you can dispute a debt at any time, but you have certain extra rights and benefits if you dispute within the 30 days after receipt of a letter that tells you you have 30 days to dispute this. And this is under the FDCPA, Fair Debt Collection Practices Act, Section 1692G. And so what Midland's saying here is, hey, go ahead and work it. It's outside the validation period, so it doesn't matter, which that's not the law. And they also say consumer needs to send proof. Remember, they're trying to shift the burden back to the consumer here. So, okay, we've got this footnote, validation 1692G, which requires debt collector validated debt when a consumer disputes a debt in writing within a certain period of time. And that's true. But you can dispute it anytime after that. And that doesn't mean that a collector can just ignore it when you also do a dispute through the credit bureaus. And even if you don't do it through the credit bureaus, if you dispute the debt and the collector continues to collect it and turns out you do not owe the debt, then you hammer the collector for doing that. So never fall into this trap of thinking, well, I've only got 30 days to dispute directly with Midland, for example. Yeah, it's better if you can do that, but dispute it at any time. Okay, so let's go back here. So February 2012 began reporting to CRA's debt was assigned and it was disputed, which they have to report that under what's called 1692E8. Says when you know a collection account is disputed, you must tell the credit bureaus. Okay. So July disputed this account with the credit bureaus. The consumer did. They notified Midland. Well, what did they tell Midland? Dispute type 1, not his, hers, verify name, address, social security, dates, balance. So Midland verified it. How? By double checking the information it reported against its own records. So they just said, well, let's look at our records and see if that matches what we told the credit bureaus. Which kind of begs the question, why would it not match? Okay, so that's not really an investigation. And they did not request account level documentation from DRS or T-Mobile. So July, they sent her another letter and say, provide documentation. So she responds, which is very smart. So many people ignore this. Don't ignore it. If they send you something, respond back to it, reiterating neither T-Mobile nor GE belong to her and requesting validation of any alleged account with Terry Lynn Hinkle. She told Midland she could not furnish Midland with anything because I do not have the alleged account. It's a pretty good argument. I mean, it's like, so think about it this way. I've got a mortgage with, let's say, Bank of America. And you're listening and you're watching this video right now, and Bank of America reports that it's your debt. Well, how do you prove it's not your debt? You're like, I don't have anything on this. It's not my debt. Okay? So, and we have to be honest when we do this, and this is not the time to people just go through like every negative item on their credit report and go, it's not mine, even when you know it's yours. All you've done there is destroyed your credibility and destroyed your ability to bring a lawsuit on the legitimate thing. So don't do that. But here she's saying, I don't have anything because it's not my account. And she told them she was going to sue them, and they continued to report it. So she filed suit. During discovery, she requested documents, written discovery, did not take depots. Trial court advised her she should seriously take depositions. She did not. Now I'll say this. She won her case on appeal, which is very, very unusual when you don't take depositions. Okay, so the fact that she got lucky here, don't ignore the fact that the judge was right to say, you know, you might want to take some depositions. You might want to put these people under oath and question them in detail. Court could very easily have ruled against her because she didn't have those depositions. Okay, but hey, she got lucky on this one, and that's good. And she also did a great job, so it's not just luck. So Midland moves for summary judgment, and the court grants that, enters judgment, case is over, and now she appeals. So standard of review is the court saying, this is how we evaluate this appeal. This is how we know whether we should affirm or keep the ruling or we should reverse it. So you view all facts and reasonable inferences in light most favorable to the non-moving party. Well, remember, Midland moved for summary judgment. So Hinkle is the non-moving party. So you have to view the facts and inferences most favorable to her. And summary judgment is appropriate where there's no genuine issue as to any material fact, and the moving party, that would be Midland, is entitled to judgment as a matter of law. Well, how do we know if a fact is in genuine, is there a genuine issue? Is this a legitimate type of dispute over a fact? If the evidence is such that a reasonable jury could return a verdict for the non-moving party, that would be the consumer. So the court is not saying, would we rule in favor of the consumer, but just saying, could a reasonable jury, could they go in favor of the consumer or in favor of the debt collector? Well, then that needs to go to the jury. Now, if it could only be in favor of the debt collector, then you grant summary judgment. So here's the discussion. The FCRA requires the credit bureaus and entities that furnish information, that's why they're called furnishers or furnishers of information, to investigate disputed information. Here's what the CRA, so we're going to focus on the CRA for just a second, must conduct a reasonable reinvestigation to determine whether the information is accurate. And this is going to be in 1681I. And then in that investigation, they're required to notify the furnisher that the information is disputed. Now, what happens then? Only when the furnisher is told by the credit bureaus, hey, this is being disputed, then the furnisher, they've got three things. Conduct an investigation. Number two, review all relevant information provided by the CRA. And number three, report the results of the investigation to the CRA. Now, what happens if the furnisher figures out it's inaccurate, incomplete, or cannot be verified? Well, then the furnisher has to either modify, delete, or permanently block the information. And then the CRAs must also delete or modify the information based on the results of their own reinvestigation. So they both have an obligation here. Now, oftentimes the CRAs will say, well, all we can do is just go to the furnisher. We have to rely on them. Sometimes that's right. But oftentimes there's enough information in the dispute that the CRA, Equifax Experience TransUnion, cannot just rely on the furnisher. They have to do their own investigation. So CRAs informed Midland that Hinkle disputed these two accounts. Midland conducted an investigation that consists of, at most, number one, double-checking the information it had to the CRAs against its own electronic database and sending her a letter saying it'd be helpful to have a copy of documentation. And the district court said those are sufficient. But here's what she argues. A down-the-line buyer must investigate mistaken identity disputes by verifying the identity of the alleged debtor against account-level documentation, not just the electronic data files. So here's where the court really starts getting into this. And if I've done this right, I've tried to highlight the sections in green. You're going to see two sections. 1681 S2B, that's for the furnisher, when they're notified by a credit bureau that there's a dispute. So if you notify the furnisher directly, that does not trigger 1681 S2B, only when the credit bureau does it. And then the other section is the 1681I. That, you think of I as investigation. The credit bureau must investigate. It's called a reinvestigation, but it investigates your dispute. So let's look at this. Matter of first impression, 11th Circuit, does not specify the nature and extent of the investigation, but they say, look, the duty of a furnisher under 1681 S2B is a component of a larger reinvestigation duty imposed by, well, I didn't do that one in green. Let me just do that real quick. 1681 IA on the CRAs themselves. So what they're saying is, look, the credit bureaus have this obligation, and furnishers, you're part of that obligation to investigate. So 1681 S2B2 requiring furnishers to complete their investigation and report its results before the expiration of the period within which the CRA is required to resolve the dispute. So you send a letter to Equifax, they get it, they've got to conclude their investigation within 30 days. So they send the notice to the furnisher. That furnisher has to get back in time so that the Equifax can complete its investigation within 30 days. So it's a subpart of the bigger investigation. All right, so let's go back here to, we previously held that 1681I, so that's for the CRA, imposes a duty to make reasonable efforts to investigate and correct, number one, inaccurate, number two, incomplete information brought to its attention by the consumer. Now, there's another section called 1681EB that says the credit bureaus have an obligation to have reasonable procedures to assure maximum possible accuracy. And that's even before you bring something to their attention, but we're not talking about that in this case. Okay, so that's a whole different claim. All right, so given the interrelated nature of 1681 S2B and 1681 I, we conclude reasonableness is an appropriate touchstone for evaluating investigations. So, let's see here. Let's grab this footnote here. Midland suggests on appeal did not take action because the time the dispute was filed, it had already marked the account paid and ceased to report it. And this is important. We are unaware of any provision in the FCRA, because there is no provision, that relieves furnishers of their obligations under 1681 S2B once they are no longer actively reporting the disputed debt. So think about it this way. If what Midland argued is true, any furnisher could put completely false stuff on your credit report and then just stop reporting. So we call that parking an account on your credit report. And they go, oh, well, we're not doing anything. We just left it on there. But if you call them and ask to get it off, they're going to say, well, here's what you have to pay to get it off. Kind of like me parking an old car in your front yard and you're going crazy over it. And I go, well, if you pay me, I'll move it. So really, this gives you insight into how these companies argue these cases. All right, so they say, what constitutes a reasonable investigation will vary depending on the circumstances. Okay, and are we looking at a CRA under 1681I or a furnisher under 1681 S2B? What is a reasonable investigation by a furnisher may vary depending on circumstances. Reasonableness depends on facts. Whether the furnisher's investigation is reasonable will depend on the status of the furnisher. Are they an original creditor? Are they a collection agency collecting on behalf of the original creditor, a debt buyer, down the line debt buyer? So that matters. And what quality of documentation is available to them. And it goes back to this very famous case called Johnson versus MBNA, where sort of the rule was, at least to my knowledge, established for the first time that when it says investigation, it means you have to do a careful sifting and evaluating and do your due diligence on whether or not this is a valid dispute. The reasoning a jury could find a 1681 S2B violation where the original creditor ended its investigation before consulting underlying documents such as account application. So now going back to our case, the facts of this case require us to determine whether a reasonable jury could find that Midland, a down-the-line debt buyer with as-is purchase agreements and no account-level documentation, fell short of the reasonable investigation standard when it relied on its internal records. So here we go. 1681 S2B contemplates 3 potential ending points. Well, what are those? Number 1, verification. Number 2, a determination that there's an inaccuracy or incompleteness. Or number 3, the information cannot be verified. And so here's Midland's argument right here. They say once it compared the information the CRAs possessed with its own information, then that's good. We can say it's verified. And the consumer goes, now wait a minute. The information you had were insufficient to verify the accounts. And so you should have said, hey, it cannot be verified. So remember, up here, 3 possibilities: verified, it's inaccurate or incomplete, or it cannot be verified. Midland says, hey, we check our own computer records. That's good enough for verified. She goes, no, it should be cannot be verified. We agree. That's not entitled to summary judgment. Now, that doesn't mean Hinkle's going to win the case. It means a jury should decide this. So how do they start their analysis? Well, this is what we normally do. We look at what's called the plain text. In other words, what are the literal words in the statute? And it requires furnishers of information to either verify disputed information by means of investigation or inform the CRAs that information cannot be verified. Now, the law does not define verify or investigation, so we look at the ordinary meaning. So here's just some case law. When terms undefined, give it ordinary meaning, turn to dictionaries even. So what does verification mean? Evidence that establishes or confirms the accuracy or truth of something. Number 2, the process of research, examination, etc. required to prove or establish authenticity or validity. Number 3, A formal assertion of the truth of something as by oath or affidavit. Number 4, short confirmatory affidavit at the end of a pleading or petition. So kind of gives you a flavor for what verification means. It's something that says we're able to determine this is actually true. Well, what does verify mean? Well, similar. So we've got a verb here, to prove to be true, to confirm or establish the truth. Confirm or substantiate by oath or affidavit, swear to the truth. Well, what does investigation mean? A detailed inquiry or systematic examination or searching inquiry. So that's that Johnson case versus MB&A, quoting American Heritage Dictionary and Webster's Dictionary. So, what do these definitions mean? Requires some degree of careful inquiry by furnishers of information. So when a furnisher does not already have or possess evidence establishing an item is true, then 1681 S2B requires furnisher to seek out and obtain such evidence before reporting the information as verified. Now, they're not saying that you have to go get that information, but if you don't get that information, then you have to say this cannot be verified. So they again cite back to that case, reversing summary judgment because a reasonable jury can find a violation of 16 S2B where furnisher did not look beyond the information contained in its internal data file and never consulted underlying documents such as account application. Here's another case. Failure to investigate properly raised where a particular credit report contains a factual deficiency or error that could have been remedied by uncovering additional facts. Well, I mean, that's what an investigation is. You go out there and try to find facts. And the court points out the requirement to uncover additional facts will be more or less intensive depending on what evidence they already possess. So a debt buyer with account level documentation, more comprehensive warranties might be in a completely different position than Midland. So they may be, but the court's not saying they definitely will be. It's just saying that's not what we have here. So 1681 S2B does not impose an unduly burdensome investigation. So, and I love the way the court presents this here. It gives the furnisher a choice. All right, you got the dispute from the credit bureau. Now, what do you want to do? Here's your first option. Conduct an investigation. Verify the information and report as being verified. Now, that might be uncovering documentary evidence. It might be somebody with personal knowledge. And when you say it's been verified, the question of whether you behaved reasonably will turn on whether you acquired sufficient evidence to support the conclusion the information was true. And normally, that's going to require a trial. But here's the second way. You could do an investigation, conclude, I can't verify it. It's unverifiable. You might determine the evidence doesn't exist or it's too hard to get. Imagine you're number 5 down the line and your contract requires you to go back to debt buyer number 4, and then they have to go to debt buyer number 3, to number 2, to number 1, who then has to go back to Capital One. Well, if everybody's charging you $200 to go get that information, you go, man, this isn't worth it. So you go, I'm not going to do an investigation. I'm just going to say it's unverifiable, or at least I'm not going to do much of an investigation. So you notify the CRAs the information cannot be verified. Now, when the CRAs get that, they have to delete it. When furnisher reports cannot be verified, the question of whether you complied with 1681 S2B will depend on whether you reasonably determine further investigation be fruitless or unduly burdensome. So let's look at the footnote here. Present case involves a report of verifying, thus does not require us to delineate a standard for cases involving a report of cannot be verified. We emphasize, however, that the law gives the furnishers a choice. But we're not saying that they have complete discretion to just cease investigation. So if a furnisher reports on you and then you dispute it, they can't just automatically say, well, we're not going to investigate. It can't be verified. But they've got to show that it would be fruitless or unduly burdensome. Now, here's the final way. It's just to say it's inaccurate or incomplete. So 3 choices: investigate and prove it's verified. Investigate and say, it's too expensive, or we will never get the information. Or number 3, investigate and say, yep, it's inaccurate information. So this framework reflects 1681 S2B is designed not only to exclude false information, but also prevent the reporting of unverifiable information. Let's drop down to footnote 9. Any other reading would render meaningless the cannot be verified option in 1681 S2B. And they go back to an 11th Circuit case from 2007. So you want to give every word, every clause some meaning. So go back to where we were here. All right. So when a furnisher determines that's false or cannot be verified, notify the CRAs. Based on your investigation, promptly modify, delete, permanently block the reporting. And what the results of the reinvestigation require may vary depending on the nature of the disputed information. But look, when they're unable to verify the identity, we're persuaded that the appropriate response will be to delete the account or cease reporting it entirely. So here's what 1681 ID. This is for the credit bureaus. Following any deletion of information which is found to be inaccurate or whose accuracy can no longer be verified, the CRA, so Equifax, Experian, TransUnion, shall furnish notification the item has been deleted to any person specifically designated by the consumer. And also, when they receive notice that an account is unverifiable, it must promptly delete that item of information from the file of the consumer. And they say, in case you think this is too strict, we hasten to observe, even though a furnisher ends an investigation without verifying, must cease reporting, this does not require the furnisher to cease dunning or otherwise attempting to collect the debt. So this is very important. Credit reporting is not the same thing as all debt collection activity. So they may not be able to keep it on your credit report, but they may still can call you, write you, or sue you. So there's a lot of parallel between credit reporting and all forms of debt collection, and credit reporting is one form of debt collection, but it's not a complete match here. All right, so we're not the only circuit to recognize this, and Johnson, that's an MBNA case, think Bank of America case. Fourth Circuit said, did the bank reasonably investigate a dispute? The consumer said, I was not a co-obligor, but merely an authorized user. The bank investigated this by confirming name and address were the same in its file. And there was a code in the computer that said solely responsible. They did not look at information, never consulted documents such as account application, which you would think would be pretty obvious, right? Person says, hey, I didn't open this account. I'm just an authorized user. Well, go look at the account, the application. And they said, based on this evidence, a jury could reasonably conclude the bank acted unreasonably when it reported that the information was verified. Now, listen to the bank's argument. Its reliance on computerized data was reasonable. Well, why? Because it destroyed the account level documentation. Well, if you destroy it, that's kind of on you, buddy. You know, you made that decision to destroy it. Court rejected this argument, explaining reasonable jury could find that the bank should have at least informed the credit agencies that could not conclusively verify the information. So, meaning of or reasoning of Johnson's doubly persuasive and down the line buyer like Midland. So, mistaken identity dispute. They investigated the dispute by confirming the identifying information possessed by the CRAs was the same as it. Oh yeah, what does that mean? That's garbage. Midland did not attempt to consult account level documentation and confirmed the Terry Hinkle and Terry Hinkle incurred the debts were the same Terry Lynn Hinkle. It was done 6 years later. So a reasonable jury, remember that's our question, summary judgment, could a reasonable jury rule either way? A reasonable jury could find such a cursory investigation, such a shallow investigation, was unreasonable in the facts of this case. A jury also could find the documentation they reviewed was insufficient, and therefore they had a duty to report the accounts as cannot be verified. And a jury could also find because Midland retained the right to seek account level documentation. Remember, that's where it's important to look at these agreements and see, can Midland go and request this information? Well, if it can, then it needs to do that. So a jury could find that because it retained the right to seek that account level documentation, it behaved unreasonably when it said the accounts were verified without exercising those rights. Now, Midland is jumping up and down because there's a case out of the 7th Circuit, which that tends to be like Illinois, Indiana. It's called Westra, does not persuade us. So this was a collection agency collecting on behalf of an original creditor and said the agency conducted a reasonable investigation when it relied on internal records to verify a disputed debt. So the court says, Midland is not a collection agency collecting on behalf of the original creditor. It says, look, Westra didn't discuss this, but it's reasonable that as an agent of the original creditor, because remember, if you're just a collection agency, you don't own the debt. The original creditor still owns it. Westra defendant could more reasonably rely on its internal records in Midland. Midland is a down-the-line buyer that purchased the accounts as is, no account-level documentation, and only after accounts had changed hands repeatedly in the secondary debt market. And even though the previous debt buyers said, well, we think it's right, they made no warranties as to whether the information was obtained from the original creditor or did they get it by way of background checks, internet research, other means. We just don't know. So let's look at the footnote here. Purchase agreement T-Mobile accounts warrants the data file purchase constitutes DRS's business records was made or compiled by DRS and was recorded either by a person with knowledge or a person who caused the data to be entered. So DRS isn't saying everything we're giving you came straight from T-Mobile. This is stuff that DRS has added. So maybe skip tracing, trying to find addresses, places of employment, phone numbers, etc. All right, so let's see here. No way to know how many times information Midland furnished changed hands or was altered. And so they don't put much stock in that. So here's Midland's two arguments. They say, here's why we should not have to do much of an investigation. First, the act of sending a letter shifted the burden to Hinkle. I like that. Shifted the burden to Hinkle to substantiate her dispute. And the court says, although the failure to respond to a letter requiring assistance might be relevant on whether Midland was entitled to report the debt as verified, we are unprepared to say it is dispositive or controlling at summary judgment. Cites nothing in the FCRA permits a furnisher to shift its burden of reasonable investigation to the consumer. And even if there was a case, which they're not saying there is, but if there was a case, they say it doesn't make any sense. The furnisher is in a far better position than the alleged debtor confirmed the actual owner. I mean, think about it. She's saying, I never had these accounts, so how can she possibly go get documentation to prove that? And so they say reasonable jury can find Midland acted unreasonably when it conditioned further investigation on a response without informing Hinkle of that requirement. And this is the thing. They didn't say you're required to. They said be helpful. But even if they had said you're required to do it, I think it's still the same result here. Or she could have responded like she did, say, I don't have anything because it was never my account. Now here's the second argument from Midland. So this first argument here gets shot down. Second argument. Investigative burden was less extensive because the notice of dispute it received from CRA stated only that the accounts were not his or hers. So there is some case law from other courts that seems to say, if you read it without reading it carefully, that if the CRA sends kind of sketchy or imprecise information to the furnisher, then we're not going to hold the furnisher to a very high standard of investigation. Which that's one reason why sometimes it makes sense to send a direct letter to the furnisher also so that you have that in their records. So let's see what the court says about this. So citing this case called the Gorman case, pertinent question is whether a procedure is reasonable in light of what it learned about the nature of the dispute from the description in the CRA's notice of dispute. Here's another case, the Westra one. Reasonable given the scant information the furnisher received regarding nature of dispute. And they say, look, we agree. Whether investigation is reasonable will depend on what the furnisher knows about the dispute. This is important. We reject the proposition that a furnisher may truncate or shorten or do a lousy job in its investigation simply because the CRA failed to exhaustively describe the dispute in its notice. So the CRA gets your dispute. They have to notify the furnisher of your dispute, and they're supposed to send your full dispute letter to them, but sometimes they just do kind of a halfway job. And the court's saying that's not going to be enough. Okay, so they differ from what other courts say here. So Gorman said, although the notice determines nature of dispute, it does not cabin or totally encompass the scope of investigation once undertaken. So the 11th Circuit's just making it real clear here. Hey, furnishers, you have to look at all your information. So that would include a direct dispute letter. So let's look at it here. When furnisher has access to dispute-related information beyond the information provided by FCRA, it will often be reasonable for a furnisher to review that additional information. So let's see. Midland also was aware of the basis of the dispute because Hinkle herself told Midland repeatedly they didn't belong to her. So a jury, that's our question, summary judgment, could a reasonable jury find that the CRAs or the furnisher in this case were at fault? A jury can find these communications were enough to convey the Midland basis of the dispute was mistaken identity or fraud. Now here's their final argument. We should affirm the district court on the alternative basis cannot prove a willful violation. So negligent violation, you get attorney's fees, you get actual or compensatory damages. A willful violation, you get punitive damages and statutory damages up to $1,000 per violation. But notice what the court says. A reasonable jury can find Midland either knowingly or recklessly reported debts as verified without obtaining sufficient documentation. So when it says willful, that also means knowingly or recklessly. So this goes back to a U.S. Supreme Court case, Safeco. Willfully failing to comply extends not only to acts known to violate the FCRA, but also to the reckless disregard of statutory duty. And they say, look, first, Midland negotiated clauses in the purchase agreements, that's why you have to see the purchase agreement in these cases, requiring the sellers to assist with obtaining account-level documentation. The fact that Midland negotiated that supports the conclusion Midland knew it might need such documentation to verify disputed accounts. So they can't go, well, it never occurred to us we should go get those documents. Hey, geniuses, you put that in your contract when you bought the debt. Second, record supports an inference system Midland used to verify information is automated, which it is, and does not incorporate review by a human capable of analyzing the dispute accounts or initiating requests for account-level documentation. So really, this is automated. The Equifax gets your dispute. They try to turn it into a couple-digit code. They send it to the furnisher. The furnishers don't want to spend any man-hours on this, so they have it automated. And it just goes, yep, that's the information we have in our system, sends it back. Court goes, that's enough to show this could be willful. A reasonable jury can find Midland adopted such a system with reckless disregard for the fact that it would result in perfunctory review in violation of the FCRA. We hold, therefore, a reasonable jury can find Midland willfully violated 1681 S2B when it reported GE and T-Mobile accounts as verified without obtaining sufficient documentation that the debts in fact belong to Hinkle. And they say, so the court erred in dismissing the claims, we reverse and remand. So that's the case. I realize this has been a long one. I have no idea how long we've been talking here, but if you stuck with me all this time, I hope that you find that helpful. And whether you are a lawyer doing this, whether you're a consumer and you're doing your own credit report disputes, or maybe you're looking at suing, or whether you're a credit repair place and you're trying to figure out, well, what is the obligation? How do I best trigger the obligations of these furnishers to make sure that they do a proper investigation, and if they don't, that the consumer will be able to go get a lawyer to sue the credit bureaus. I hope that this is helpful to you. I'll continue to do these, and this case is referenced by a whole bunch of cases in the 11th Circuit. And so we'll start looking at those and kind of see, okay, well, what are subsequent cases doing with this Hinkle decision? Are they following it? Are they kind of pulling back a little bit from it? What are they doing? So I hope you found it helpful. Feel free to leave questions, comments below. Now, if you have a kind of a private matter, say, hey, I want to know if this dispute was handled properly, you're always welcome to reach out to us. You can call us 205-879-2447, and just let the receptionist know that either you live in Alabama or you don't live in Alabama and what your situation is. We definitely will talk to you if you're in Alabama. If you're outside of Alabama, we can talk about whether it makes sense for us to help you maybe file suit in Alabama, or if you need a lawyer in your state. Or you can contact us through our website, alabamaconsumer.com, and you'll see tons of information on there. Just go to the contact page. And thanks for watching us. If you like this, feel free to subscribe to our channel, and we will have more of these coming. Okay, thanks a lot, guys. Bye-bye.